Hello and thank you for joining us on the Law Gallery, coming to you from the Lagos studios of KAFTAN Television. Khalid, Bada is my name, and I'll be starting the program on an interesting note today with a quote that says, "A lawyer is that person that writes a 10,000 word document and calls it a brief." So today we'll be talking about contracts. What is contract, and what are the reasons for having contract? Who can write a contract? Why do we need to have a contract? And knowledges of everything in between. As you know, the Law Gallery is where we get to discuss the Nigerian rule of law and everything concerning the practice of law in Nigeria. Before we go into the discussion, we'll go on a short break now to bring you the news updates on the program today. We'll be back.
Thank you, Khalid, and welcome to the news segment on the Law Gallery today. Reaching you from the Lagos studio, I am Ejimba Vivian. First, in our news update for today, the camps of People's Democratic Party flag bearer Atiku Abubakar and Labour presidential candidate Peter Obi have protested a report that said there was no evidence to support the fabricated allegations against President Bola Tinubu. In a fact-checked report published on Wednesday, the Global Disinformation Team said Tinubu forged the Chicago State University certificates he submitted to the Independent National Electoral Commission to contest the February presidential election. He said there was no evidence. The report concluded that the allegation that Mr. Tinubu presented a fake CSU certificate to INEC was false. The Global Disinformation Team said it fact-checked the most widely circulated claims to reach its conclusions. The fabrication allegations against Tinubu have thrown national politics into turmoil, with Atiku and Obi his rivals in the last election, placing the blame on the former Lagos State Governor. Reports that the former Lagos State Governor's certificate was faked went viral on social media after the CSU degree documents were made public. The release of the president's academic documents is the culmination of a lawsuit filed by former Vice President Atiku in the Supreme Court in August, seeking to overturn Tinubu's election victory. Mr. Atiku had accused Mr. Tinubu of forging the CSU Bachelor of Science in Business Administration degree awarded in 1979 to the Electoral Commission. To strengthen the election complaint filed with the Supreme Court, the PDP standard-bearer asked a court in Chicago, Illinois, to compel the CSU to obtain the president's educational records, including copies of all diplomas issued by the CSU in 1979. The petition to compel publication, a diploma with a font, sealed signature and wording similar to those awarded to other students and the one awarded to him by CSU in 1979. He also asked the CSU for documents certified by then CSU official Jama Orr. Atiku's request was rejected by Tinubu's lawyers, citing privacy concerns. But the U.S. court ruled that the process should proceed, and the school subsequently released the academic records. Following the court's ruling, Atiku's lawyer Angela Liu questioned CSU registrar Caleb Westberg in her affidavits. In another story, the Economic and Financial Crimes Commission recovered a total of 27,184,354,524 naira and 19,084,419 US dollars from 3 separate money laundering cases. The EFCC's Media and Public Affairs Director, Mr. Dele Oyewale, disclosed this on Wednesday, reiterating that the anti-corruption agency is working to recover more illicit funds. He also revealed that some former governors, ministers, and officials across the country are under investigation following multiple petitions. Oyewale said details will be announced in due course. The EFCC spokesperson made the remarks on behalf of the acting chairman of the EFCC, Mr. Abdulkarim Chuko, during a media interaction with selected journalists in Lagos. Mr. Oyewale said the EFCC had seized several houses in the Federal Capital Territory, Lagos State, and Cross River States. These were proceeds from funds allocated to the Mabilia and Tanil power projects, which were diverted through various change station operators. Finally, for today, following the political quagmire in Ondo State, Human rights lawyer Allen Sowore has called on the State House of Assembly to adopt the doctrine of necessity to overcome it. Sowore said the political quagmire the state is facing is a result of the absence of Governor Rotimi Akeredolu and the proposed impeachment of the deputy, Honorable Lucky Ayedatiwa. He said since Governor Akeredolu announced his return from sick leave, he has not been seen in the state, while the deputy who should hold the fort is moving around the country to keep him out of dismiss. In a statement titled Ondo's Political Quagmire, time to invoke doctrine of necessity is now. Sowore said Congress should apply the doctrine of necessity and applied when Yar'Adua fell ill and he did not transfer power to Jonathan, his vice president. Sowore said that in accordance with the provision of Section 188 of the 1999 Constitution of the Federal Republic of Nigeria, as amended, and following due procedure and proceedings, it is evident that the covert plot by Governor Oluwatodimu to impeach his deputy, Lucky Ayedatiwa, has failed woefully. These are the duties imposed by the Constitution on the Speaker of the Ondo State House of Assembly, and it is essential to carry them out conscientiously and patriotically to prevent a slide into anarchy due to lack of governance. Similarly, as true friends and staunch allies of the governor, members of the cabal and the state assembly, on moral grounds, can also advise him to resign and prioritize taking on responsibilities that are appropriate for his health. Sowore said that it is not ideal, and of course, this display of desperation and overambition by government officials to outsmart one another at the expense of the lives and welfare of our people goes against the core Yoruba philosophical concepts of Omoluabi, which our state is renowned for. That's all on the news updates today. Stick around as we join Khalid and Barrister Oluwatodimu Ige for the rest of the program.
Welcome back from the news update. It's still the Law Gallery coming to you from the Lagos studios of KAFTAN Television. And before we go on the break, I mentioned that we will be discussing contracts today on the program, the reasons we have contracts, and why we should definitely, why organizations and individuals should write contract, and everything that should be embedded in the contract. Now today we'll be joined by a brilliant legal practitioner. We've had him on the program one time, and he's joining us again on the program. He's a legal practitioner and a content creator. He goes by the name Barrister Oluwatodimu Ige, also known as Oga the Lawyer. Thank you for joining us on the program today.
Thank you very much for having me, Mr.
How are you, sir?
Thank you. I'm good.
Now, we're discussing contract.
Very well.
I think before we go into the reasons for having contracts and the things that should be included in contracts, we should first talk about a contract as a concept on its own. What is a contract? Because we only know it at the layman level. Okay, a contract is just an agreement. You understand? What is contract in itself?
Well, yes, as it stands, I always prefer to make it as simple as possible.
Okay.
A contract, like you have said, is an agreement.
Mm.
When there is a contract, it could be a formal contract, it could be an informal contract. As many people believe that because it's not documented, it cannot be enforced. That is,
okay.
That's an erroneous belief. The fact that, okay, I'll give you an example. You want to board a vehicle from Oshodi to Iyanokpaja.
Okay.
The conductor says, oh, Iyanokpaja is 100 naira. You get into the vehicle, and the bus stops midway and says, get down after you have paid. What happens? Do you just walk away? Of course, you want a refund, or you ask that the driver and the conductor get you to your destination. Yes. What has happened in effect is that there has been a contract between, though it's not formal, there is no documentation to that effect, but it means that there has been a contract, there is a contract in existence between the party, the offer and the acceptance. The conductor offered the Iyanokpaja for 100 naira, you have accepted to come on the vehicle, so it means that there is a contract in play. Every step of our daily strata, we run into contracts, because for every opportunity, for every business, for every engagement, for every discussion, most times a contract is in play.
So just for clarification purpose, there are two types of contracts, the formal and the informal.
Yes.
The formal is the written contract, while the informal is the unwritten contract,
yes,
or just
verbal,
by word, the verbal contract.
Yes.
Now, in which case should we actually have a formal contract? Now, you just gave an example of a situation between a passenger and a driver. Well, before we even go to the discussion of when we should have a formal contract, now, for an informal contract between two parties, let's say a contract has been breached between I and an individual who has an informal contract or an unwritten contract. How then do I fight for my rights? Because how do I claim, we actually had this agreement?
Yes, that's the challenge with informal contracts, because it is best advisable that you go for a formal contract. Now, in the event that there is no formal contract, when you have an agreement with the other party, the first thing that would, of course, establish that there is a contract is the steps taken by both parties.
Okay.
Oh, Mr. Khalid, when you come into the office today, I'm going to give you my phone.
Okay.
In exchange for my food. I get into the office, I give you my food, and you have refused to hand over your phone. And I ate the food. The steps that you have taken shows that by accepting the food and even taking a step further to eat the food means that you have taken steps in that contract.
Contract, yes.
Number two, witnesses. Our colleagues were in the office when we discussed this engagement. So those are steps that you can actually use to get what is due to you in the contract when there is a breach.
Thank you very much. Now, in place of a formal contract, who can write a formal contract?
Well, the truth of it is that anybody can actually prepare a contract. But it is better and best prepared by a lawyer. And the reason is because when we are talking about a contract, people have seen instances wherein people will just go to Google and download a template. Well, there might be nothing wrong in that, but when you give such services to a lawyer, it is bespoke.
Okay.
The lawyer goes into the specific nature of the contract, ensures that there is no ambiguity in the terms of the contract. Let me give you an example. Somebody says, I want to order 10 bags from a vendor, and says, I need 10 bags. The lawyer will go further to say, are you talking about 10 cockroach yellow bags, 5 yellow bags, 2 blue bags, 1, the time of delivery? What time are you making the payment? Those are elements that can bring disputes. And the lawyer would have looked into that and be sure that they are taking instructions properly and spelled it out so that there is no ambiguity, because those are the issues that come up. At times you even look at in a contract, you are saying, okay, I'm buying 10 bags. Is the cost of delivery inclusive? Who bears the cost of delivery? In the event that the dispatch rider gets into an accident, who bears the loss? So those are factors that can affect the performance of the contract. And if that happens, the lawyer would have taken care of such elements.
So it is advisable to give the drafting of a contract to a legal practitioner or an expert who will be able to, mention all the key elements in the contract. Now, what are the common mistakes will people make in contract writing or in contract drafting? Maybe from your own personal experience.
Okay, yes, now in respect of contracts, number one, most people, let's look at an example of probably most times when a tenant has defaulted or a tenant even wants to come into a property. There's a tenancy agreement. It's a contract.
Okay.
The tenant comes in and they say, read. I said, don't worry. My own is just to get into the house. And the landlord has said that you must come in by 11 p.m. You must not bring in a generator or pet into the house. You opened your 2 eyes and you signed. Or the landlord says that at the expiration of your rent, you are only entitled to 7 days notice.
Okay. Because
you are eager to get into the property. You say, oh yes, let me just sign a bam. And when time comes and the landlord is saying, why are you bringing a pet into the property? There's a contract to that effect. You now begin to cry. So number one from what I've said, the number one mistake people make is getting into a contract without understanding fully what they are going into. There is no need to rush a contract. You need to get clarity. What is this? Because even full stops in the contract means something. So you shouldn't just assume that they said, okay, in the event that A does not happen, B will happen. So it's A, B, C now, A for apple, B for ball. You might find yourself in a big mess. Number two is that when people get into contracts, they misrepresent information. And it's fundamental. Somebody says to you, I'm selling you this property, and uses his name as Mr. Oluwatodimu is selling to Mr. Khalid. And the property actually belongs to KAFTAN TV. You see that as it stands, there is a fundamental error, because there's a law, there is a strike law that you can't give what you don't have. Definitely. So how would Mr. Khalid sell a property that belongs to KAFTAN? That's another fundamental mistake when when there is a contract. Number three is that there has to be clarity. Like I said earlier, what exactly are the deliverables? What are the terms and conditions of performing this contract? In the event that this cannot even happen, or there is an error, or there is a mistake, what are the timelines? How do parties communicate? What form of notices should be given to each other before legal action? These days, because of the ADR mechanism, it is encouraged that before parties go to court, they should sit down and see how they can resolve issues. And that's what we call the alternative dispute resolution. And now, in instances like that, when there is ADR, how many days do parties have to come together? So those are factors that must be clearly considered. Yes.
Now, is there a possibility of maybe adjusting a contract after it has been signed? Let's say I came into agreement with a landlord that maybe I won't be bringing in a pet, or I won't be having a generator. Now, there is a change in situation. Maybe, take for an example, an area that used to have stable electricity, then they stopped having the stable electricity. Now, is there a possibility of adjustment, or a contract is rigid? Let's say, okay, is a contract flexible or rigid?
Yes. Okay, now, that's the beauty of having a lawyer draft a contract, because in such instances, there would be a clause wherein there's room for contract review. And the event that there's a contract review, whatever documents it must be consensual. That means that you cannot on your own decide to amend the contract. The other party has to consent to whatever adjustment. Now, what you will now do is have an addendum to the contract. So the addendum carries the same weight as the original document. Now, like you have said, the example you give that you have, because there's electricity issue, there's a need to introduce your own generator. There's a need for you to introduce your solar system. It will be wicked or unreasonable for the other party, not wicked, but unreasonable for the other party not to consent to you bringing in your generator. Now, to further moderate that, so that you don't put on your generator all day, all night, the addendum will now read that, yes, you can come in with your generator, but it must go off at so time. Who bears the cost of foiling the generator? So many, at times, it's not even the tenant that wants to come in with it. It could even be the facility manager that says, we are introducing a generator. So those are things that can come in the contract. You can always review the cost of the transaction.
Now, what are the things to watch out for before signing the contract? Let's say I'm coming into agreement with a person, and a contract has been drafted by a legal practitioner. Now, who protects the right of the person that is going to sign? Now, a contract has been drafted by my lawyer, and such contract has been given to me. Who protects my rights? How do I review such contracts? What do I look out for?
Okay. Now, we have clients who just put us on retainer because they want us to review their contracts.
Okay.
So, it is not even logical. It doesn't make any sense for you to get a contract and just sign without getting expert opinion. So most times, before you sign a contract, what we do, even if we are the one drafting the contract, is we share it with you, the PDF format, so that you can go through it. If you have any concerns or area that you need clarification on, or there are even times that you need to take out a particular clause or rephrase certain things, so that way the lawyers on that transaction would exchange a lot of emails before they arrive at the final documents.
Thank you very much for that. Now, organizations also make use of contract. We understand, and these contracts can vary between maybe financial transactions or share. Maybe let's say an organization that shares border, maybe compound or something. How do you clarify different clauses? Let's say, okay, I'm coming in agreement with you. We are going to be agreeing on transportation, electricity, water. Do we have all of those in one contract, or there is a need to always specify, have different contracts for different subjects?
Well, if it depends on the nature of the relationship. Let's just say that if it's a shared space, one contract can fit all. You're talking about, this is how I want to run the electricity, this is how I want to pay for security, this is how I want to pay for whatever. It can be all contained in one document. There are contracts that can be 50 pages, 30 pages. It's tidier that way. But if it's different parties, of course, like the landlord has about 4 or 5 tenants, that can be lumped, that cannot be lumped into one document because it is separate. Everybody has their own, must have their own separate contracts.
Now, there is a situation of confidentiality agreement and non-disclosure clause.
Very well.
How does that come into contracts?
Yes. Now, if parties are to go into a transaction and they want to protect the information and the data, it is expedient and important that at times it could be embedded in the body of the contract, non-disclosure, that parties who are not part of this contract ordinarily should not know what exactly is going on, the nature of your relationship. However, there are some instances that even before you go into the contract, before there is any disclosure, the party that is giving that information would mandate that the other party, the receiving party now, signs what we call a non-disclosure, so that whatever you have discussed with me, in the event that we don't even go into a contract, I cannot use that information anywhere else.
Okay.
There are instances that we might decide not to go into the transaction, but I should not divulge the sensitive and confidential information that I've been privy of as a result of that discussion.
Now, in a situation where someone breaches a contract, an agreement between individuals, how do we handle such situation?
Yes. In law, we say that when there is a breach, there is always a remedy. That means that if you have, and the law is also very clear that parties are bound by contract that they have willingly entered into. You understand? Because you can't say, oh yes, I used to like him, but now I don't like him again, so I'm no longer interested in the contract. No, that one you can talk about moral or relationship. But when it comes to having a contract, regardless of whether you like the person or not, you must perform the obligations placed on you by that contract. However, in contracts, there are termination clauses, and you must abide by such clauses. Like, for example, you will see that if somebody wants to put in a notice of resignation at an organization, most typically would say that you give 1 month notice or you forfeit a month's pay.
Yeah.
So you cannot put that on emotions and say, I'm not happy with my boss, I'm not even coming to work. That means that if that's a breach and your employer or the employee can actually come after you for damages, and such an action will succeed if there's a breach of the agreement. So I think that basically that's how it works.
As a legal practitioner, have you had an experience where there is a breach of contract?
Well, so many. And it's quite unfortunate that the climate that we are in now, it is becoming more rampant. Particularly, you see people who take out loans from banks. There have been instances that the first day that they even took the loan, some would ask you to make monthly repayments. Some instances in matters that were handled, We have discovered that some would not even make any form of payment right from day one, 3, 4 years. That's a breach. Tenancy agreements. Some would enter into an agreement with the landlord and promise not to, and undertake not to sublet such properties. And you will discover that from day one, he did not even stay in the property for 1 day. He subletted it to somebody else. That's a breach. There are so many, and it borders on, most times, the contract, no matter how the fine print is. I always say that it's the spirit behind the contract that matters. Because when people enter into a contract, are they ready to be bound by the terms of the contract? And that's what leads to breaches. Some people will just say, let's just sign there so that we'll get the money. Let's just sign so they will give us the contract. And at the end of the day, they deliver some standard products. They don't do their part, and that's what causes breach.
And how do you undo those disputes?
Yes. Now, in the eventuality that there's been a breach in contract, the first thing to do is to notify the other party of the dispute. How do you do that? You do a letter of demand.
Okay. Asking
them, one, to fulfill their obligation, or probably ask for a refund. After, you could give 7 to 14 days or 21 days, depends on the terms and conditions of the contract. After that, if there is no response or performance by the other party, you can, of course, I mentioned earlier that you can also have what we call the alternative dispute resolution. If there is an ADR clause, you bring that into operation. If after that is not resolved, parties can now go to court. And what are you going to court for? There's what we call to ask the court for an order of specific performance. What does that mean? If I'm saying that you have to supply me 12 loaves of bread, and I'm asking the court that please ensure that Mr. Khalid supplies me the 12 loaves of bread, that's specific performance. And if he cannot supply these 12 loaves of bread, ask him to refund me. Then at this point, I'll be asking for damages. Because when there is a breach, like I said, there's a remedy. You must restore me to the other to the position that you met me, and even leave me better, because I should not be at a disadvantage. I've employed the services of a lawyer. I've paid money to go to court. I shouldn't bear the brunt of your ineptitude.
Have you been in a situation where someone breaches a contract due to unforeseen circumstances? Maybe there is a contract to deliver a certain good, and an accident happens. Therefore, such person was not able to fulfill that contract. Have you been in such a situation where someone like that breaches such contract, and how do you undo that? Because I understand that there is the concept of mens rea, where you look at the intention of doing something. Yeah. Now, such person that has breached such contract doesn't have the intention of breaching it, but they broke it due to unforeseen circumstance. How do you handle such situation?
Now, that's an intelligent question, and the truth of it is that when you are drafting contracts, there's what we call the force majeure.
Okay.
What does that mean? It means that an act of God, like you have mentioned. Let's just give an example of the 2020, the COVID year.
Okay.
We have a contract to supply diesel to Ibadan, and the government has said that no, there should be no movement. No matter what you do, except you use witchcraft,
you can't.
You cannot deliver. So that's force majeure. That's on circumstances that are beyond the control of the parties, and it's evident there is an earthquake.
Okay.
So the contract would, of course, provide for such acts of God or natural disasters, war, and so many other things.
Thank you very much for that clarification. Now, what would be your advice to anybody that's going to sign a contract? Or before we go into that discussion, I understand that a lot of times, as individuals, we register things online. Maybe you're applying for or social media, or your anything online. There is an agreement. They will tell you to click I agree to the terms and conditions of this. Is that a form of contract? Because a lot of times we don't read terms and conditions. No one particularly does. We just agree. Is that a form of contract?
Yes, and it's something fundamental as well. It is a contract. You will see that they would say that I, so and so, consent to the conditions listed above. There are some would even now. you would see that for those who borrow money from these online apps, some of them would even put in their fine prints that you are consenting to them releasing your pictures or contacting your family, friends, and members, having access to your phone book. Later, you now come to the lawyer and say, how are they contacting my family members? Did you not sign? Because that's their defense. That at the time of taking this loan, you clicked on, I hereby accept that unauthorized access to my phone, to my phone contacts, and so many other things. So it is very important that anytime you are clicking any form of document that requires your assent, that requires your consent, you must be sure that you are giving consent with your full chest, not that you are in a rush, because the law would not look at it from that perspective. Yes, it doesn't look at your emotion. Did you click yes or no? It's simple.
Thank you very much for that. Now, what would be your advice to our viewers, who probably intend, or definitely everybody would one time or the other sign a contract? What would be your advice to them?
Yes, number one, when you are going to sign or enter into any form of agreement, you must be ready to be bound by the terms of the contract. You must ensure that whatever you are signing, you understand it clearly. If you are in doubt, ask questions. Do not be pressured into going into a contract because you are bound by the terms of the contract. Number two is that don't promise what you cannot give. Because it's a contract. You don't say, sorry, it's because I needed money that I signed that I'll pay 20% per annum. You have signed. You are, and you are when in such instances, you are bound by the terms of what you have signed. And finally on that, because like we all know, circumstances change. Eventually, life happens, as they say. When you see that you would not be able to perform a contract, communication is very important. Communicate to the other party. Do not become defensive or unnecessarily aggressive. Reach out to the other party. Let's come to the table and see how, if it were to be a loan, there's what we call loan restructuring. You can discuss with the bank and say, how can we restructure? If it were to be a tenancy agreement, you see that by the end of the year, when your rent is due, you will not be able to meet up. You have ample time. When it's the 8th month, reach out to the landlord and say, I'm sorry, I might not be able to meet up. Can I have a month or 2 months extension? When there is communication, it makes life easy. And I think that that's the way to go.
Thank you very much, Barrister. I really appreciate your time.
You're welcome. Thank you for having me.
Yeah. There you have it, our dear viewers. We have understood and established the fact that a contract is a legal binding between individuals and organizations. And in a situation where you have to sign a contract, first you need to understand every clause of the contract, because there are situations of ambiguity. Therefore, you need to understand that, and you also need to always seek the advice of a legal practitioner. They understand the job better. It is their job to do it. Don't just believe, okay, I understand English. English is what is written here. I've read it and I understood it. No, there are times where the interpretation on a layman level is different when it comes to the legal practice. And with that, I'll be wrapping up the program for this week. To come back same time, same station, I remain Khalid. Bada. Bye for now.